possibly. Again, that comes under the force majeure term, which is that it applies to both sides, not just to the purchaser. So a seller could claim that via this this virus that it really is to be considered an act of God. It doesn't really, that term probably isn't what a lot of people think it is. It's not completely literal, so it could be something that is completely man-made but just kind of unanticipated. So if it's something that neither side could anticipate, then certainly you could use the force majeure clause. Both sides could. If a contract was signed after the outbreak was well known, then either side is going to have a tough time getting out of parts of those contract, unless you sign a new contract and stated that the seller is not going to allow those people in, and you sign the agreement anyway as a buyer, then the buyer is going to be stuck and the seller could get out. But if it's just your standard contract and the buyer wants to have those people in, certainly if the seller refuses, I think the buyer could deem the contract to be canceled and get their deposit returned. But would the buyer be able to convince a judge that they have to sell them that home based on that? Probably not. There's probably enough reasonableness in regard to that argument where a seller would not have to do that, but I don't think they could keep the buyer's deposit unless that was specifically delineated in the contract and the buyer signed it.